The Honorable, the Chief Justice, and to the Associate Justices of the Supreme Court of the United States. Oh yes, oh yes, oh yes. All persons having businesses before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We will hear argument this morning in case 19-1392, Dobbs versus Jackson Women's Health Organization.
Mr. Chief Justice, and may it please the court, Roe versus Wade and Planned Parenthood versus Casey's hurt our country. They have no basis in the Constitution. They have no home in our history or traditions. They damage the democratic process. They choke compromise. They poison the court. For 50 years, they've kept this court at the center of a political battle it can never resolve. Roe and Casey have failed, but the people of Mississippi, if given the chance, will succeed. The Constitution places its trust in the people. On hard issue after hard issue, the people have made this country work. This court should overrule Roe and Casey and let Mississippians determine whether or not to protect unborn children's lives. I welcome the court's question.
Counsel, I want to be clear about what you're arguing and not arguing. As I understand it, you're arguing that the Constitution is silent and therefore neutral on the question of abortion. In other words, that the Constitution is not pro-life or pro-choice, but leaves the issue for the people of the states to resolve in the democratic process. Is that accurate?
Yes, Your Honor.
And so, even if you were to prevail, the states, many states, some states could continue to allow abortion. Is that correct?
That's consistent with our view, Justice Kavanaugh. It's one that allows all interests to have full voice. A little something for everyone.
A little something for everyone except pregnant women.
Thank you, Mr. Stewart.
Counsel, I'd like to...
Mr. Stewart, if I were to ask you which constitutional right protects access to abortion, is it privacy? Is it autonomy? What would it be?
Whichever one you're focusing on, Justice Thomas, each of them is a step removed from the Constitution. Yes, the Constitution does protect certain aspects of privacy, of autonomy, and the like. But going directly from abstract concepts to specific rights isn't how this court traditionally does due process analysis.
Do you mean to say that privacy and autonomy are abstract?
No, Justice Sotomayor. I mean, in any case, abortion isn't mentioned in the Constitution.
The word woman isn't mentioned in the Constitution either. Does that mean?
Be that as it may, the crux of your case is whether or not Roe and Casey were wrongly decided. Is it not? It's part of our stare decisis doctrine that precedence isn't an inexorable command and that there are circumstances in which overruling is possible, even desirable. Plessy versus Ferguson, for example, and Brown versus Board of Education, both of which righted egregious wrongs, did they not? But in thinking about stare decisis, whether or not precedent should stand, how should we evaluate precedents in such volatile cases? Casey explicitly takes into account public reaction to Roe versus Wade. Is that a factor you accept, or are you arguing that we should minimize that factor?
What I'd emphasize, Chief Justice Roberts, is that people, many people really just want to have the matter returned to them so they can decide it locally. Deal with it in the way they think best, depending on the dictates of their conscience. This is a hot, difficult issue for everyone, and the last 50 years have made things worse, not better. Roe is dividing this country.
All the more reason.
I assume you've read Roe pretty thoroughly.
Yes, Justice Breyer.
You claim that Roe versus Wade has politicized the court. It's a danger, I grant you that. But wouldn't overruling Roe also politicize the court? It's particularly important to show we're not caving into social pressure, or political pressure for that matter. not to mention the fact that new members of the court have tipped the balance of power in your direction.
Surely you don't mean that, Justice Breyer. There is no such thing as conservative and liberal justices, not on my watch anyway. We don't have Obama judges or Trump judges, Bush judges or Clinton judges. Our job is to call balls and strikes, not to pitch or bat or legislate from the bench.
God forbid.
What we have is an extraordinary group of dedicated judges doing their level best to be impartial.
Is that why Mitch McConnell blocked Merrick Garland?
Just because the legislative branch has gone the way of banana republics doesn't mean we have.
Prove it.
Are you threatening me?
Of course not. I'm challenging you to put your vote where your mouth is, to uphold Roe.
I'm not so sure this is a good idea, airing out our dirty laundry like this.
You'd prefer to shred the rule of law behind closed doors?
Standard practice. You know that as well as I do.
Not so fast. I'd like to read a couple of sentences from Casey, if I may, to clarify what's at stake. To overrule under fire in the absence of the most compelling reason, to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. All right, what do you say to that?
Are you talking to me?
I'm talking to Mr. Stewart. Unless you'd like to openly argue on behalf of the plaintiff.
No comment.
What about you, Mr. Stewart? You're not worried that overturning Roe versus Wade would undermine the court's legitimacy?
Not really. What I mean to say, in the light of, we now have 50 years of evidence to see what Roe has done and what it hasn't done.
Well, it's caused some good things in the eyes of some people, and some bad things in the eyes of others.
Let's call a spade, shall we? What hasn't been at issue for the last 50 years is a woman's right to choose and the right to control her own body. 30 justices over 50 years have reaffirmed this right. 4 have said no, 2 of them members of this court. But 30 justices have said yes, of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, admit they're challenging Roe because we have new justices on the Supreme Court. Will this institution survive the stench this creates in the public perception that the Constitution and its reading are just political acts?
Needless to say, the Mississippi House bill never should have said that out loud.
The truth will out, Mr. Stewart. And I don't see how the legitimacy of the court can survive if people believe that everything, including Roe versus Wade, is politically motivated. I could name any other set of rights, including the Second Amendment, by the way. There are many political people who believe the court erred in saying that bearing arms is a personal right as opposed to a militia right.
Don't be ridiculous.
You haven't answered my question, counsel.
Justice Sotomayor, I think the concern about appearing political makes it absolutely imperative that the court reach a decision well grounded in the Constitution, in text, structure, history, and tradition, and that we carefully consider the stare decisis factors we've laid out.
Casey already went through every one of them, point by point.
No, it didn't, Your Honor, respectfully.
You think Casey's reasoning was wrong? That's your belief. But the Supreme Court has already rendered its decision.
Well, Your Honor.
And you haven't added.
Sorry, Your Honor.
Haven't added anything other than I disagree with Casey. Not a very compelling argument, Mr. Stewart.
Maybe I can highlight a problem or two. Casey doesn't account for the last 30 years of advancements in medicine, science, all those things.
What are the advancements in medicine you refer to, counsel?
I think it's an advancement in knowledge about fetal pain, things like that. We know that an unborn girl is fully human from a very early.
A gross minority of doctors believe fetal pain exists before viability, before a brain cortex is formed, in other words.
That's not what.
Pre-viability fetal pain is a belief, not a scientific fact.
But
How is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time. I gather it's still debated in religious circles. When do you believe a human life actually begins?
Your Honor, aside from.
Mr. Stewart, I know what Roe versus Wade said about viability, but was viability an issue in Casey?
I don't think it was squarely at issue in Casey, Your Honor.
Which means viability hasn't been litigated since Roe.
Exactly.
May I finish my inquiry?
Of course, Justice Sotomayor.
Virtually every state defines brain death as death. Yet the literature is filled with episodes of people who are completely and utterly brain dead responding to stimuli. Clearly, a response by a fetus doesn't prove there's a sensation of pain, let alone consciousness. You haven't provided a shred of evidence that there's viability before 23 to 24 weeks.
What about fetal personhood, Your Honor? Roe versus Wade's core holding is that we can only protect an unborn girl's life after viability, when she can survive outside the womb, but not when she needs us most. Pre-viability. This is not the world the Constitution promises.
Why do you keep referring to the fetus as a girl?
It's inclusive.
It's offensive.
Think of it as the kind of fetal feminism, protecting the rights of unborn glorious synapses.
That's rich coming from you.
You're never satisfied, are you? First you complain we exclude you, now you're offended because we bend over backwards to include you.
Give them an inch, they'll take an L.
Now, let's not fight amongst ourselves. It's unseemly. One way or the other, the crux of the case is viability, isn't it?
Exactly. I've searched high and low for reference to anything remotely related to viability in the Constitution, in the Bill of Rights, in every single amendment to every single constitutional clause. Am I missing something?
That's the cornerstone of our case against Roe, Justice Thomas. Viability isn't tethered to anything in the Constitution, in history or tradition. It's a quintessentially legislative line.
Counsel, there's so much that's not in the Constitution, including the idea that the Supreme Court has the last word on things like guns and abortion. And yet, what the court does on a day-to-day basis is render decisions based on the structure of the Constitution. Accordingly, we've recognized parents' rights to educate their children at home, to teach them the religion of their choice. We've recognized people's right to choose who they're going to marry. I fear none of these things are written in the Constitution. Why do you now say that somehow Roe and Casey are so unusual that they must be overturned?
Well, Justice, I would emphasize.
Would a decision in your favor call into question any of the cases Justice Sotomayor just mentioned?
No, Justice Barrett.
Yeah, right.
What about Griswold Lawrence and Obergefell?
First of all, the vast majority of these cases have more clearly defined parameters. You can't ban contraception, can't ban intimate romantic relationships between consenting adults, can't ban same-sex marriages, none of which impinge on the rights of others the way Roe does.
What about Masterpiece Cake Shop versus Colorado? The evangelical cake baker case.
Well, with all due respect, Justice Breyer, surely queer wedding cakes are a bridge too far.
In other words, you're dissimulating when you say that overturning Roe wouldn't have an effect on those cases.
Heaven forbid.
That pretty much says it all.
Forgive me. I'm sorry to interrupt again, but I'm having trouble following your logic here. Where do you draw the line? Last time I checked, neither queer cakes nor gay marriage is explicitly mentioned in the Constitution. I'm not trying to argue we should overturn Obergefell, mind you. But do you really think states like Mississippi and Texas and Florida aren't going to challenge these cases in court? We would be opening the floodgates, wouldn't we?
I mean, Your Honor, we've always have a diversity of views, and people will vigorously debate and make decisions for themselves.
That's the point, isn't it? Making decisions for ourselves. When does the life of a woman enter into the calculus? Forcing women who are poor to give birth, and that's 75% of the population in Mississippi, puts them at 4 times greater risk of serious medical complications, if not death, than having an abortion before viability. And now the state is saying to these women, your bodies are not your own. The state has jurisdiction over you. The state intends to force you to bear a child, to compromise your ability to earn a living, temporarily, if not permanently, to put your life on the line, whether you like it or not. Because we know better than you do.
Justice Sotomayor.
Chief Justice Roberts.
If I've told you once, I've told you 1,000 times. Whips aren't allowed in the courtroom.
And guns are?
Of course. They're in the Constitution, remember?
By which you mean we're a well-ordered militia.
Something like that.
Silly me. I thought we were here to safeguard against martial law, not enforce it.
You're quite right. Who needs guns when we've got a supermajority?
Is that a gun in your pocket, or are you just happy to see me?
A little bit of both.
Order in the court. Well, we're almost out of time. I just have a few little, well, not little, I hope, questions. And the first gets back to the issue of viability. You know, in your petition for cert, your first question, and the only one in which we granted review, was whether or not all pre-viability prohibitions on elective abortions are unconstitutional. And then I think it's fair to say that when you got to the brief on the merits, you kind of shifted gears and talked about whether or not Roe and Casey should be overruled, not just modified. And I wanted to give you a chance to explain this this shift.
A couple points, Your Honor. So at the petition stage, we emphasized that the court was going to need to reconsider, revisit, and reevaluate something or other. The merits, if I'm remembering correctly, if not the viability clause. Take your pick as to whether the court should overrule, take that momentous step. We presented our best arguments for that. That's what we've done, Mr. Chief Justice. I rest my case.
Thank you, Counsel. Justice Thomas?
No further questions.
Justice Kavanaugh? Justice Breyer? Justice Sotomayor?
Why bother?
Thank you, Counsel.
Thank you, Chief Justice.
Ms. Rinkelman?
Mr. Chief Justice, and may it please the court, Mississippi's ban on abortion 2 months before viability is flatly unconstitutional under decades of precedent. Mississippi asked the court to dismantle this precedent and allow states to force women to remain pregnant and give birth against their will. The court should refuse to do so for at least 3 reasons. First, stare decisis presents an especially high bar here. In Casey, this court carefully examined and rejected every possible reason for overruling Roe, holding that a woman's right to end a pregnancy before viability was a rule of law and a component of liberty we could not renounce. Second, Casey and Roe were correct. For a state to take control of a woman's body and demand that she go through all the physical risks and life-altering consequences of pregnancy and childbirth is a fundamental deprivation of her liberty. Preserving a woman's right to make this decision until viability protects her liberty while logically balancing the other's interests at stake. Third, eliminating or reducing the right to abortion will propel women backwards. 2 generations have now relied on this right, and 1 out of every 4 women makes the decision to end a pregnancy. To avoid profound damage to women's liberty, equality, and the rule of law, the court should affirm Roe versus Wade.
I'm going to ask you the same question I asked Mr. Stewart. I've searched high and low, Ms. Reichelman, spent sleepless nights poring over the sacred words of our divinely inspired slave-holding founding fathers, looking for textual evidence in support of your theory of the case. If we were interpreting the Second Amendment, I know exactly what we're talking about. If we were interpreting the Fourth Amendment, I'd know what we're talking about because it's written. It's there. What specifically are we talking about in Roe versus Wade? Is it liberty? Is it autonomy? Is it privacy? What is it?
It's liberty, Your Honor. It's the textual protection of the 14th Amendment that a state can't deprive a person of liberty without due process of law. Allowing a state to take control of a woman's body and forcing her to undergo the physical demands, risks, and life-altering consequences of pregnancy is a fundamental deprivation of her liberty.
Did any state constitutional provision recognize that abortion was a right, liberty, or immunity in 1868 when the 14th Amendment was adopted?
No, Your Honor. But there was a tradition under the common law for centuries of women being able to end their pregnancies. At the time of the founding and well into the 1800s, women freely exercised this right.
The brief for the American Historical Association says that abortion wasn't legal before quickening in 26 out of 37 states at the time when the 14th Amendment was adopted. Is that correct?
That is correct, Your Honor. But those 26 states discarded the common law because of a discriminatory view that a woman's proper place was a wife and mother, a view that the Constitution now rejects. Until 1860, even the Catholic Church allowed abortion for what they called ensouling, their term for viability or quickening. That's why it's appropriate to historicize reproductive rights. Otherwise, the Constitution might reinforce historical discrimination against women.
And?
Is that a question, Justice Thomas?
It's the question, Ms. Reichelman.
I'm afraid I don't understand.
All men are created equal, are they not?
It's the cornerstone of our founding documents.
Precisely. Now we're getting somewhere. Let's parse that phrase, shall we? All men are created equal. From an originalist perspective, the way the founding fathers themselves understood it, what do you suppose they meant by all men?
Let's not go there, Justice Thomas.
Why not? Ms. Reichelman claims that the Constitution no longer reinforces historical discrimination against women, of all things. I'd like to give her an opportunity to defend her position.
I must confess, I don't see how this line of questioning relates to Dobbs versus Jackson Women's Health Organization.
I know.
You have a question, Justice Barrett?
That is why I'm here. To make sexist questions seem less offensive, let alone sexist rulings. I'm the Uncle Tom of jurisprudence pertaining to women. No offense, Justice Thomas.
None taken. It's a compliment coming from you.
Mrs. Rickleman, I take it you think women are entitled to the inalienable rights enjoyed by all men, referred to in all men are created equal.
Needless to say,
that being the case, why draw the line there? In the spirit of the never-ending quest to expand the purview of human rights, don't fetuses deserve the same consideration?
with all due respect, Your Honor, so-called fetal personhood isn't at issue in this case.
I'll be the judge of that. Do you have children, Mrs. Rickleman?
I hardly think that's relevant.
Says who? Justice Sotomayor doesn't have children, you know. Neither does Justice Kagan. Much to the detriment of their judgment, if you ask me. Have you been blessed with children?
2 girls.
Only 2? I've got 7 children, you know. 2 of whom are adopted. Which leads me to my next question. Both Roe and Casey emphasize the consequences of forced parenting and the obligations of motherhood that flow from pregnancy. Why don't the safe haven laws take care of the problem? There is, without question, an infringement on bodily autonomy, not unlike vaccines, but that doesn't mean pregnancy and parenthood are all part of the same burden. Mr. Stewart's brief points out that in all 50 states, you can terminate parental rights by relinquishing a newborn. Leave the baby at a firehouse, for example, or a police station. Not to mention adoption agencies. Why didn't you address the safe haven laws, and why don't they matter?
They don't matter for a number of reasons, Your Honor. The idea that a woman can place a child up for adoption has, of course, been true since Roe and Casey. So it's consideration the court has already addressed when it decided those cases and adhered to the viability line. Pregnancy imposes unique physical demands and risks on women, and in fact, has impact on their ability to care for other children, other family members, on their ability to work. And those risks are alarmingly high. It's 75 times more dangerous to give birth in Mississippi than it is to have a pre-viability abortion. And those risks are disproportionately threatening the lives of women of color. Finally, there's the emotional burden of forcing a woman to choose whether or not to give a child up for adoption.
That proves my point, not yours. How could any woman in her right mind resist the idea of wrapping these booties around the precious little toes of a newborn? You're a mother. Don't they tug at your heartstrings, Mrs. Rickelman?
Have you ever considered how rape and incest might affect a woman's heartstrings?
The Mississippi House bill doesn't take rape and incest into account, and neither should you. A soul is a soul, no matter how it was conceived.
So much for the separation of church and state.
Mrs. Rickelman was the one who brought up ensoulment, not me.
Ensoulment after viability, not before.
Aye, there's the rub. Let's turn to the question at hand. Whether Mississippi has the right to prohibit abortions at 15 weeks rather than 23 or 24. A minor adjustment in the larger scheme of things, if you ask me. Not a total ban. Surely viability and choice aren't as closely linked as you say they are, Miss Reichelman.
Before we shift gears, I'd like to follow up on something Justice Barrett said about vaccines and bodily integrity.
Very well. I'll allow it, against my better judgment.
Thanks, Chief. I hardly think vaccines and abortion are comparable. Do you? With references to bodily integrity, that is, not to mention public health.
They're not comparable by any measurable standard, Your Honor. Pregnancy impacts a woman's bodily integrity for at least 9 months, even without serious medical complications. Vaccines, on the other hand, only take a minute and are minimally invasive.
Assuming they don't contain microchip tracking devices.
Or make your balls blow up like balloons, like Nicki Minaj's cousin's best friend.
Let's save questions about vaccines for next week when we consider whether or not to block the president's vaccine mandates.
Talk about a no-brainer.
Here again, you're not worried about the court's legitimacy? Telling women what to do with their bodies is fair game, apparently. But asking everyone else to take a life-saving vaccine is unlawful. Why? Because it infringes on their right to infect other people? You're not just telegraphing double standards, you're broadcasting them.
Don't be ridiculous. Fox News would never dream of broadcasting our double standards.
Foul ball. We're here to interpret the Constitution, not pander to the press, let alone public opinion.
Even though the vast majority of Americans favor reproductive rights?
Especially because the majority of Americans favor reproductive rights. Who are they to decide what is or isn't ethical or legal?
That was the crux of Mr. Stewart's argument, wasn't it? Letting the people of Mississippi decide whether or not to uphold Roe versus Wade. Somehow they're allowed to make ethical decisions, even though the majority of Americans aren't qualified to do so. Yet another double standard.
Hoisted with his own petard.
Need I remind you, I'm the Chief Justice. This is my court, and I'll be the judge of what is or isn't a double standard.
I love it when he gets hot and bothered like that, don't you?
Preferably behind closed doors.
Ms. Regelman, I read your brief, which states, somewhat inexplicably, that the only real option we have is to reaffirm Roe and Casey as they stand or to overrule them in their entirety. You say that there are no half measures here. Is that correct understanding of your brief?
Your Honor, we're responding to Mississippi's request to replace viability with a 15-week ban. As you well know, the viability line is the central holding in both Roe and Casey. Without it, there's no real way to uphold a woman's constitutional right to abortion. If the Mississippi House bill prevails, then states with 6-week bans, 8-week bans, 10-week bans, and so on would seek to enforce them without any recourse to the scope of the liberty interest going forward. States will rush to ban abortion at virtually any point in pregnancy. It's a textbook definition of slippery slope, Your Honor.
So much the better, by which I mean, this particular case is only asking for a 15-week ban. As far as viability goes, I don't see what that has to do with the question of choice at all.
With all due respect, Your Honor, people who need abortions after 15 weeks are often in the most challenging circumstances. They are often people with a major health or life change, a family illness, a job loss, separation, young people or people who are on contraception or pregnant for the first time and were delayed in recognizing the signs of pregnancy, or poor women who often have more trouble navigating access to care. And if they are denied the ability to make this decision because there's a ban after the 10 weeks, they'll suffer all the consequences the court has talked about in the past. In fact, the data over the last 50 years has clearly shown that abortion has been critical to women's equal participation in society. It's been critical to their health, their lives, and their ability to pursue.
I'm sorry, what kind of data is that?
I would refer to the court brief of The Economist in this case, which compiles data showing how the legalization of abortion has enhanced women's access to education and professional opportunity.
Well, putting data aside, if you think the issue is one of choice, that women should have a choice to terminate their pregnancies, doesn't 15 weeks provide ample time to make that decision? Because viability doesn't have anything to do with choice, does it?
As the court repeatedly emphasized in Roe and Casey and June Medical, for example, the viability line has both a biological and a logical justification, making the point when the fetus is capable of meaningful life.
Not so fast. That's a syllogism, not a justification.
A syllogism or a tautology?
A syllogism, without a doubt, as follows. Premise: viability marks the point at which a fetus can survive on its own. Premise: abortion is legal until a fetus can survive on its own. Conclusion: therefore, viability justifies the right to abortion. A logical fallacy if there ever was one.
A logical fallacy, to be sure, but a tautology, not a syllogism, as follows. The viability line is justified because the fetus is capable of meaningful life.
Strictly speaking, that's circular reasoning, not a true tautology at all. If we're going to expose Ms. Regelman's logical fallacies, we need to be precise.
The clock is ticking, gentlemen. While you're engaging in rhetorical pissing contests, women in Mississippi are faced with the grim prospect of terminating pregnancies without access to medical care. You can't really ban abortions, you know. You can only ban safe abortions. And only if you flout the Equal Protection Clause of the 14th Amendment.
Are you arguing this case, Justice Sotomayor? Or should we let Ms. Reichelman represent the baby killers? I mean, the pro-choice side of this argument.
If I may, I'd like to address the question of viability once and for all. It is a clear and workable line that preserves the essential components of liberty and autonomy, and has the advantage of being a rule of law for over 50 years.
Yes and no. The problem with your argument is that you're only accounting for one side of the equation. There are two interests at stake, the life of the mother and the life of the fetus. And one interest has to prevail over the other at any given point in time. In your brief, you say the existing framework accommodates, that's your word, both the pregnant woman and the fetus. But according to Mr. Stewart's brief, you can't accommodate both interests, Ms. Rickleman. You have to pick. The core problem here is that you're forcing the court to pick sides on the most contentious social debate in American life, The Mississippi House bill argues that the Constitution is neutral on the question of abortion. And because the Constitution is neutral, this court should be scrupulously neutral, neither pro-choice nor pro-life, because we don't have the authority to rule one way or the other. So we should return to a position of neutrality and leave the question of abortion to the states, to the people of Mississippi. That's Mr. Stewart's argument in a nutshell, if I'm not mistaken. And I want to give you a chance to respond to it.
Yes, a few points, Your Honor. First, those very same arguments were made in Casey, and the court rejected them, saying that this philosophical disagreement can't be resolved in a way that women have no choice in the matter. And second, I don't think it would be a neutral position. The Constitution provides a guarantee of liberty, including the ability to make decisions relating to childbearing, marriage, and family. Women have an equal right to liberty under the Constitution, Your Honor. If they're not able to make this decision, if states take control of women's bodies and force them to endure months of pregnancy and childbirth, they'll never have equal status under the Constitution.
I hardly think that liberty and equality are interchangeable, Ms. Rickleman, as your argument seems to suggest. Be that as it may, I'd like to ask a follow-up question about how do I say that?
Stare decisis. I had to look it up.
Stare decisis. Thank you. I'll start that line again. I hardly think that liberty and equality are interchangeable, Ms. Rickleman, as your argument seems to suggest. Be that as it may, I'd like to ask a follow-up question about the stare decisis, picking up on Justice Breyer's comments. When you really dig into it, as I have, the history of stare decisis tells a somewhat different story than is sometimes assumed. We all know that one of the most consequential cases in the court's history involved the overruling precedent. Brown v. Board of Education outlawed separate but equal. Baker versus Carr set the stage for one person, one vote. More recently, Lawrence v. Texas, which said that the state can't prohibit same-sex conduct. Gideon versus Wainwright, which guaranteed the right to counsel in criminal cases. Obergefell, which recognized a constitutional right to same-sex marriage. I assume you agree with most, if not all of these decisions, each of which overruled a precedent. So the question on stare decisis is why, if, and I know you disagree with what I'm about to say in the if we think that precedents are seriously wrong, then why doesn't the history of this court's practice require us to overrule them?
Because the view that a previous precedent was wrong has never been enough for this court to overrule, especially when there's 50 years of precedent. Instead, the court has required something else, a special justification. And if Mississippi hasn't come forward with any special justification, they make the exact same arguments the court had already considered and rejected in the stare decisis analysis in Casey. If this court renounces the liberty interests recognized in Roe and reaffirmed in Casey, it would be an unprecedented contradiction of individual rights and a stark departure from principles of the stare decisis. In fact, the court has never revoked a right that is so fundamental to so many Americans and so central to their ability to participate fully and equally in society. Furthermore, the real-world effects of overruling Roe and Casey would be severe and swift. Nearly half the states are poised and ready to enact bans on abortion in all stages of pregnancy, many without exceptions for rape or incest. To borrow a line from Mr. Stewart's brief, this is not the world the Constitution promises.
You make a very forceful argument and identify critically important interests that are in stake in this issue, no doubt about it. Too bad we've already made up our minds.
I must say I'm mystified by your position, Ms. Reichelman. Do you mean to say that a case can never be overruled on the grounds that it is egregiously wrong?
At the very least, the state would have to come forward with some kind of materially changed circumstance or some kind of materially new argument, and Mississippi hasn't done so in this case.
Really? Suppose Plessy versus Ferguson was re-argued in 1897, smack in the middle of Jim Crow. Would it not have been sufficient to say that it was an egregiously wrong decision from day one, the minute it was handed down, and should therefore be overruled?
Without a doubt. Plessy versus Ferguson was egregiously wrong on the day it was handed down, but the court is still required to provide a special justification. Had Brown versus Board of Education not exposed the hypocrisy of the separate but equal doctrine, Plessy wouldn't have been overturned, at least not yet.
Do you really?
And here, Mississippi hasn't.
You actually think there are no circumstances in which a decision may be overruled, properly overruled, when it must be overruled simply because it was egregiously wrong at the moment it was decided?
I think
Is that correct?
every
Is that your position?
stare decisis factor likewise.
Yes or no, Ms. Reichelman? Stop equivocating.
No. This court has never overruled solely based on the conclusion that a decision was wrong. If stare decisis is to mean anything, it has to mean that overruling precedent requires strict scrutiny of the original argument, a point-by-point analysis of precedent. Quite literally the only way to ensure the rule of law going forward. Casey did that. It applied the stare decisis factors to Roe, which means what we're dealing with here is precedent on precedent, doubly settled law.
Counsel, you keep emphasizing that the court drew the line at viability in Roe and reaffirmed it in Casey. And that's certainly something that we have to take into consideration. But suppose we were considering this question for the first time. I'm sure you know the arguments about the viability line as well as I do, probably better than I do. What would you say to the idea that the line really doesn't make any sense? That is, as Chief Justice Roberts himself described it, arbitrary?
You're asking me to ignore stare decisis?
Sure, why not?
Because, as I have already indicated, the stare decisis doctrine is the cornerstone of the rule of law.
Not if you're effectively hiding behind the doctrine, Mrs. Rickelman. Does this mean you can't defend the viability line in and of itself?
The court itself has consistently ruled that the viability is a principled line, the most.
Yes, but we're fighting the hypothetical here, counsel. Accept the hypothetical. Surely, if a woman wants to be free from the burdens of pregnancy, that interest doesn't disappear the moment the viability line is crossed. What is the secular philosophical argument for saying this is the appropriate line?
I hate to interrupt. I really do. But I can't help but think the word secular is a telltale sign that we're wandered into dangerous territory, where the religious view has somehow wormed its way into our deliberations. Could this possibly be true?
Heaven forbid.
That's the second time you've said that. Yet another tell.
And that's the second time you've said you hate to interrupt. A ridiculous assertion, given your tendency to pontificate.
My tendency to pontificate.
Pontificating goes with the territory, gentlemen. What doesn't go with the territory is this public display of discord, this infighting. I won't allow it. As Justice Breyer is wont to say, the court's legitimacy relies on the appearance of collegiality, if not unanimity.
I never said that.
We're all one big happy family, remember? Doctrinal differences notwithstanding. Justice Ginsburg and Justice Scalia frequently accompanied one another to the opera. Justice Scalia taught Justice Kagan how to shoot a gun, if you can believe it. They even went hunting together. Isn't that right, Justice Kagan?
You may have noticed that 2 of those justices are no longer with us.
And?
The collegiality of the court may not have survived Justice Ginsburg's passing, for obvious reasons.
I do wish you'd make more of an effort to get along.
To play nicely with the other children.
Something like that. Decorum is essential to the reputation of the Roberts Court.
The Roberts Court or the Thomas Court?
6 of one, half a dozen of the other.
I beg your pardon?
Nothing. Getting back to the task at hand, does the viability line really hold up under strict scrutiny, given the philosophical questions posed by the fetal personhood?
With all due respect, no one will ever be able to answer these questions. No one in this court, anyway. Philosophy, secular or otherwise, is the purview of philosophers, not justices who are charged with interpreting the Constitution, not speculating on the meaning and origin of life. Viability is the most principled, workable line because it balances all the interests at stake. including the fetus's ability to survive separately, without requiring the court to resolve unresolvable philosophical debates.
Which leads us back to the question of stare decisis.
Talk about beating a dead horse.
I'd like to read from Casey again, if I may. As you well know, the majority opinion is written in two parts. Part 1 reaffirms Roe versus Wade. The second part enumerates the stare decisis principles that clinch the case. In light of this due diligence, and I quote, only the most convincing justification can show that a later decision overruling Roe is anything but a surrender to political pressures or new members of the court, unquote. New members, mind you, their words, not mine. The last sentences of Casey also warns that overruling Roe versus Wade would undermine our ability to function as the Supreme Court of a nation dedicated to the rule of law. They didn't refer to this outcome as a stench, Justice Sotomayor's characterization of the case, if only because of the Burger Court was more collegial than the Roberts Court. Mr. Stewart has assured us that we need not worry about damaging the Supreme Court's legitimacy. What do you think, Ms. Rickelman? Have you reflected on the larger implications of this case? Above and beyond the question of whether a 15-week ban really effectively guts Roe?
It's not my place to tell the court how to conduct itself. I'm here to uphold the rule of law. And the rule of law demands that the court reaffirm the rights of women, which have been justified beyond a shadow of a doubt in Roe and Casey.
No one should have to tell the court how to conduct itself. Yet here we are, on the brink of what amounts to a constitutional crisis. It's not enough that the executive and legislative branches of our government are imploding. Are we really going to follow suit? Rereading Casey, I'm struck by its assessment of the historical significance of Roe versus Wade. It says Roe is special. What's special about it? It calls it a watershed case. Why? Because the country is divided, because feelings run high. And yet the country, for better or for worse, has decided to resolve their differences by this court laying down a constitutional principle. In this case, a woman's right to control her own body. In watershed cases such as this, it's particularly important to show that we're not a political institution whose rulings swing back and forth depending on what part of the public yells loudest. It's what Hamilton meant when he said that we wield neither the sword nor the purse, that our legitimacy relies on people's belief that we aren't just politicians in robes, dressing up partisan politics in the guise of legal proceedings. Judging from the tenor of oral arguments thus far, I fear we're in danger of jeopardizing our authority, if not our legitimacy.
Enough already. How do you think I feel? It's my court. And if you think I want to go down in history as the Chief Justice who allowed blatant partisan politics to run rampant, you've got another thing coming. When it comes to the High Court, the art of the deal, it requires an invisible hand steering our rulings into an ultra-conservative direction without sinking the ship of state. This isn't the first court to try and make the contraction of rights looks like fidelity to the Constitution. But the times they are a-changin'. Try as we might, we can't ignore the woeful fact that the majority of we, the people, are moving in one direction, toward an expansion of equality, while my court desperately tries to turn back the clock, to make America great again, to borrow a phrase, otherwise known as owning the libs. We need to proceed incrementally, privileging religious liberties without appearing to violate the separation of church and state, advancing the interests of heteronormative rich white men without appearing to marginalize Black, Brown, Indigenous, queer, and other appropriately disenfranchised groups who aren't up to the task of governing themselves. The operative word is appearance, a simulacrum of justice. Not unlike the Statue of Liberty, which seems to welcome the huddled masses even as the United States slams its borders shut to safeguard the white supremacy that made America great in the first place.
Stop! I'm getting all hot and bothered just thinking about heteronormative white supremacists.
Fellow conservatives, lend me your ear. Dobbs versus Jackson Women's Health is an ingenious bill, tailor-made to gut Roe while maintaining the illusion of choice, but only if we allow the 15-week ban to stand, at least for now, to cover our tracks. A wolf in sheep's clothing comes to mind, an apt metaphor for the Roberts Court, if I do say so myself. But don't get me wrong, I want to throw Roe to the ash heap of history as much as you do, though I would never say it out loud.
You just did.
I just did what?
You said it out loud.
Oops. What I meant to say, of course, is that we would never dream of overruling Roe without making sure that every last stare decisis consideration is subjected to strict scrutiny. A double, triple, quadruple level of judicial review designed, in part, to safeguard the reputation of this august institution.
Why bother? Nobody's really paying attention anyway, except maybe a handful of feminazis. The majority of Americans are too busy fighting over COVID vaccines and whether or not the January 6th assault on the Capitol was heroic or not. Besides, who needs judicial review when you've got Fox News on our side?
Not to mention the fact that Justice Ginsburg is gone. Finally, and we can do as we please.
The changing of the guard, so to speak, ushering in a whole new era of not so compassionate conservatism. Justice Ginsburg must be rolling in her grave.
One can only hope.
Ding dong, the witch is dead.
Witch, old witch.
The wicked witch.
Ding dong, the wicked witch is dead.
Ding dong, Mary-O, sing it high.
Sing it low. Let them know the wicked witch is dead.
Order in the court. Let's see now. Where were we?
I'd like to underscore the number of times the members of this court have declared that Roe versus Wade is settled law and that viability is...
You've made that point abundantly clear, Ms. Reichelman. For what it's worth.
Any further questions?
Enough already.
Justice Kavanaugh. Justice Breyer. Justice Sotomayor.
No further questions.
Thank you, Counsel.
Thank you, Chief Justice.
The case is hereby submitted for review at 11:54 a.m. December 1st, 2021.
A date which will live in infamy.
The beginning of the end of democracy.
Over my dead body. Did you miss me? When the cat's away, the mice will play, that's for sure. Who knew you could make so much mischief in the brief span of time since my untimely demise? Mind you, I'm well aware that people say I should have retired earlier, by which they mean I'm responsible for the conservative supermajority on the court. You mustn't think we can't hear you on Mount Olympus. The acoustics are amazing there. I'd like to set the record straight once and for all. Don't blame me for the fact that Donald Trump defeated Hillary Clinton. That Mitch McConnell cares more about demagoguery than democracy, let alone the fact that Justice Barrett isn't so much a rhino, a Republican in name only, as a wino, a woman in name only.
Did somebody say wino? Cheers.
As for you, frat boy, occupying the Honorable Justice Kennedy's seat, do you have any idea how much damage you've already done to this institution? I fault myself in a way for letting it happen. Now that I've got a little distance from it all, death has a way of cutting through all the bullshit. I can acknowledge the mistakes we made, welcoming you with open arms when we should have called a stench a stench. to quote Justice Sotomayor. And that's not all. We let this pomp and circumstance go to our heads. All the power we wield due in part to the dereliction of the other two branches of government, who dump all their dysfunction at our doorstep. That's no excuse, mind you. I'm well aware of my own narcissistic tendencies, leaning into my rock star status instead of discouraging it. Making a video of my workout in the courthouse gym of all things, basking in my 15 minutes of fame like an elderly Kardashian. Notorious RGB my ass. Not to mention holding on to my seat well past my expiration date. It's a cautionary tale, Justice Breyer. Make way for the next generation already. It all boils down to one of the 7 deadly sins, pride. Flattering myself that I was somehow irreplaceable, that only I could save the day, even now, descending from the heavens to beat back the rising tide of testosterone on the court. I have to tell you in particular, Justice Kavanaugh, given your dangerously fragile ego, but you're just another judge, no more, no less, pretending to be supreme, pretending to have some kind of divine right, a relic of the monarchy we rebelled against. And this is what kills us as an institution, this pretense that we're above partisan politics, which obscures the fact that we're just as prone to corruption as the other two branches of government. All the more dangerous because there are no checks and balances on the Supreme Court, whose unelected members serve for life, whose confirmation hearings are performative at best, sideshows at worst, just as Justices Thomas and Kavanaugh. Which reminds me, now that I'm no longer bound by the court's insidious civility, yet another vector of hypocrisy, I'd like to pose a question I've been dying to ask you to. Did you do it?
I beg your pardon.
You'd be better off begging the pardon of Anita Hill and Christine Blasey Ford. Fess up now. Did you do it?
I did not have sex with a woman.
The Clinton defense, tried and true and guaranteed to telegraph the unimpeachable integrity of men in power, lack of integrity notwithstanding. After all, boys will be boys.
I'll drink to that.
Cheers.
And that's what this is all about, isn't it? Boys will be boys. You have your way with us in every conceivable way. And then you leave us holding the bag, or the fetus, as the case may be, which you dare to call a person while denying our right to personhood. An embryo endowed with the unalienable rights of life, liberty, and the pursuit of happiness. What's next? Fetal 401ks? I thought I could leave it in your hands, Justice Sotomayor, to carry the torch of justice in the face of the tyranny of testosterone. But relying on heroic measures won't address the fact that this court is rotten to the core. Any institution that pretends to be infallible is bound to abuse its power. Have we learned nothing from 2 millennia of religious malfeasance? Speaking of which, what's with all the religious nuts on the bench? Republicans are yelling and screaming about Democrats threatening to pack the court, but it's already been packed with religious extremists whose raison d'etre is overruling Roe. Congratulations. The moment you've been waiting for has finally arrived. The pièce de résistance of judicial activism, the swan song of democracy, overturning Roe versus Wade, the ultimate expression of what all men are created equal has meant all along. You know me, I'd like to believe that the arc of the moral universe is long, but it bends towards justice. If this turns out to be true, it will be in spite of and not because of the Supreme Court, whose name alone disqualifies it as an agent of equality. We're better off calling it the People's Court now.
That's a television show.
And this is a circus. Take your pick. Now, if you'll excuse me, I will do what I came here to do.
Fasten your seatbelts, gentlemen.
Like I said, I'm not here to save the day. I just left my purse behind my former seat on the bench, the one currently occupied by the gag dummy of the female persuasion. Little on the nose, don't you think? I'm tempted to impart one last pearl of wisdom. Having pontificated for so many years, perched up there on my high horse, it's a difficult habit to break. We all remember the apocryphal story of Benjamin Franklin's description of the Constitutional Convention of 1787. When asked what kind of government the delegates had devised, he replied, "A republic, if you can keep it." Listening to the proceedings of your court, Chief Justice Roberts, I'm afraid Franklin's admonition is too high-minded to meet the moment. A gangster version is much more appropriate, given your indifference to the rule of law. Nice little democracy you've got there. Be a shame if something happened to it. No need to call the Sergeant at Arms, Chief. I'll see myself out.
Talk about a showstopper.
Nonsense. The demise of democracy doesn't mean the end of the conservative agenda. If anything, it enhances our authority. Nothing can stop us now. At long last, the city on the hill is nigh.
America as God intended it.
A theocracy of the chosen few.
The beginning of the end of democracy as we know it. Talk about an inside job. Was it Abraham Lincoln who said that the real threat to our freedoms will come not from the outside, but from within? I suppose I could always resign and protest. A lot of good it would do. Mitch McConnell would just block President Biden's nomination, and another Federalist Society judge would be elevated to the court. I'll be damned if I'm going to go down without a fight. If the arc of the moral universe doesn't bend towards justice, it's on us, people. We, the people.
Oh yes, oh yes, oh yes. All persons having business before the Honorable, the Infallible, the Supreme Courts of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We will hear argument this afternoon in case 19-1393, Christian Soldiers Incorporated versus What's Left of the Rule of Law.